Hello, everyone. So go ahead and get started while people are still shuffling in. I'm Hasti Rezevi, a student co-chair of the Iranian American Bar Association's Washington, D.C. chapter, and I have the distinct pleasure of serving as your moderator for this important webinar. IABA's mission is to educate the community about legal issues of interest to Iranian Americans, protect and advance the rights of Iranian Americans and other minority groups, promote and foster the achievements of Iranian American legal professionals, and fundraise for law student scholarships. This year, IABA DC is putting on a series of Know Your Rights webinars and in-person meetups, so please follow our social media channels to stay engaged. Tonight, we're delighted to be joined by Larry McDonough, who will be leading us through a discussion on tenants' rights in public and subsidized housing. Larry has been a legal services and pro bono civil litigation attorney since 1983, working for Mid-Minnesota Legal Aid as a staff and managing housing attorney, private firm pro bono litigation counsel, and housing litigator with other nonprofits. He has represented over 11,000 clients with 250 trials, 1,000 motion hearings, and scores of appeals under his belt, along with drafting housing legislation, creating housing clinics, and law school teaching. He maintains the popular website Housing Law in Minnesota. Larry currently works for two organizations. He joined the National Housing Law Project in October 2022 as a part-time senior fellow. His focus at NHLP is updating the HUD housing programs, Tenants' Rights, also known as the Green Book, and other publications. He joined Homeline in December 2022 as a part-time policy attorney. His focus at Homeline is housing legislation. Thank you everyone for joining us. And without further ado, I'll turn it over to Larry. Please feel free to put in questions into the chat throughout the presentation, or we will have a Q&A at the end of the presentation as well. Larry.
Great, thank you. It's great to be here. I enjoy teaching on this subject, and so happy to be here. I'm going to share my slides, and also the slides will be available when we're done. And so I will just get started here. Let's see if, there we go. So give me a thumbs up if you can see my slides. Okay, excellent. So I'm gonna focus on public and subsidized housing, but also talk a little bit about private housing along the way. And yeah, so let's get started. So this is my contact information. So I'm happy to consult on cases and strategizing. So feel free to contact me if you want. And there's my biography, which of course is a pack of lives like everybody else's. But anyway, it's fun reading. So a couple of pitches. If you're doing housing work in the public and subsidized housing area and you're not a member of the Housing Justice Network listserv, it's a good idea to join. The principal thing is you can bounce questions of cases on people that do this work all over the country. At Housing Law Project, we participate in that, but also legal aid attorneys from around the country. When I worked at legal aid, I often, as a younger attorney, would pose questions. And as I got a little more experienced, I would help answer those questions. So it's a very good resource. At Housing Law Project, we already mentioned the HUD housing program, Tenants' Rights. If you're doing public and subsidized housing eviction work or admissions work, it's a nice publication to have. I don't get a kickback on it, so don't worry about that. We have a digital version and also a print version. And it's really helpful in digesting cases. And I have sites to the Green Book as part of the slides here today. So these slides, I have hyperlinks in them. Apparently I'm a high-tech guy with not enough to do, so I like using hyperlinks. So when you have a digital version of this slideshow, you'll be able to move around with a hyperlink. So if you wanted to read up on, go right to the CARES Act, you can go right there, talk about that, and then go right back to the agenda, and you're back there again. And so this tells you a little bit about what we're covering. Hopefully this isn't too overwhelming, and don't worry, we are going to keep this under an hour, and I'm good at doing that kind of stuff. So don't worry looking at the agenda that you think that you might have to get your camping gear out and stay for a few days. You won't have to. Okay, this is the rest of the agenda, and so let's dig into it. Some resources that are out there, of course, are the HUD housing programs, manual. Chapter 11 is the one that focuses on eviction and subsidy terminations, but there also are some other slideshows that go into more detail. This slideshow has about 60 slides in it, but in doing this work, it's nice to get more in the weeds in it. And so the other slideshows, are more probably in the 150 category, as well as other kind of manuals and things here. In Minnesota, I've created a lot of different answer forms for different types of eviction cases, like if you had a Section 8 voucher case or you have a HUD subsidized project case. And even though that wouldn't be relevant in, DC or Maryland or Virginia, it is a good, a little bit of a nice checklist for analyzing cases. Okay. When you're doing this kind of work, you need to, if you have any aversion to federal regulations from when you took tax class in law school or something like that, you just have to let that wash off yourself. There are regulations in both HUD for the major housing programs, but also Ag Department regs here for the rural housing program. There also are different HUD handbooks and letters and guidebooks and notices and things like that, and I have links to them where they are appropriate. Some areas around the country have a right to counsel. I think there might be a right to counsel in Maryland, but I'm not quite sure on that. The reason I know about that is if you're in a right to counsel jurisdiction and you don't work for legal aid, you might actually get paid to do work in this area. So you can go to the righttocounsel.org website, and they have a state-by-state breakdown as to what kind of right to counsel programs exist. If you work for a legal services program, does anyone mind giving me like a thumbs up if they work in a legal aid program? I'll see it on the screen if you do. The reason I go into this is because there are some limitations on what legal aid attorneys can do that are funded by the Federal Legal Services Corporation, but those limitations are actually quite modest. They really are focused on a limited type of cases. So prohibited from defending any person in an eviction proceeding. That person's been charged or convicted with these various drug things. So again, charged or convicted. If they haven't been charged, haven't been convicted, it doesn't apply. If it's public housing, if it's something other than public housing, it doesn't apply. So here's a list of all the things that this regulation would not prohibit. So if you're not a LSC funded attorney, you don't care about it. If there's an eviction notice but no proceeding, doesn't apply. If it's not public housing, it's some other type of subsidized housing, doesn't apply. If the client is not a person who's convicted or charged, so maybe the person is alleged to have done the conduct but wasn't convicted or charged, or let's say a household member has been convicted or charged, but your client is not that household member, you're free to represent. In the area of drugs, if you can kind of see the list of things that would not be covered if there hasn't been an illegal sale or distribution, if there's been no intent to sell. So you can see there's quite a bit left that folks can do, even if they are an LSC attorney. So let's talk a little bit about the CARES Act. You might have heard about the CARES Act. It was the law that went into effect in 2020 that expanded unemployment benefits. It had an eviction moratorium in it. Most of that stuff's evaporated, but what is still around is a 30-day notice requirement for covered properties. We'll get to that in a moment. This notice provision requirement is not limited to non-payment of rent. Courts have differed around the country as to whether it applies to breach of lease cases or just to non-payment of rent. It has no expiration date on it. So what's a covered property? Well, kind of the alphabet soup of public and subsidized housing. Pretty much everything in public and subsidized housing category, including HUD properties, including IRS tax credit properties, rural housing service properties under the agricultural department, were all covered. On top of that, properties with federally backed mortgage loan or federally backed multifamily mortgage loans covered. So basically that's private housing as well that has that type of loan. So if you're representing a tenant in an eviction case, you need to figure out if the CARES Act applies, whether it's subsidized housing. If it's subsidized housing, it applies. but there are a lot of landlords that may not know about this federally backed mortgage or federally backed multifamily mortgage loan coverage as well. So I'm here in my home tonight. That's my piano in the background. If we have time at the end, I can talk to you about my favorite jazz pianist of all time, but I'll just save that as a tease. But let's say I was a landlord, and let's say I'm a single family landlord. Let's say I got a tenant upstairs. I would need to know if my loan was federally backed. I don't happen to know that, but I'm not a landlord, so I don't need to know. But my mortgage has probably shifted in the last 20 years, probably 5 times. I'd need to figure out if it's federally backed, because if it's federally backed, I'd have to give this 30-day notice. If it wasn't, then I'd only look to local law as to whether I'd have to give that notice. So in my view, tenant attorneys in every case ought to figure out if the CARES Act applies or if it doesn't. There are more resources on the CARES Act in the longer slideshows, and we have a memo at National Housing Law Project. There's a section of the Green Book about it, so you can get more details about it if you need them. Now, separate from the CARES Act, there is a HUD requirement for a 30-day notice. It doesn't cover as many types of properties. So it covers basically everything in the public and subsidized housing world, except it doesn't apply to the voucher programs, the Housing Choice Voucher or the Project-Based Voucher Program. It doesn't apply to the Rural Housing Service because that's a different agency, that's the Ag Department. And it doesn't apply to the Low Housing Tax Credit Program because that's again another agency, the IRS. Okay. Now the CARES Act covers all those. This one just doesn't cover those. So you might say, well, who cares? Okay. We got the CARES Act, 30-day notice, and we got the HUD thing, 30-day notice, and the HUD thing doesn't cover as many programs. So why do we care? Well, we care because it has content requirement. The CARES Act does not have a content requirement, just has to be a 30-day notice before the landlord would start an eviction process. But the HUD notice has content requirements that are listed here. And so if the landlord gave a CARES Act notice and they were covered by this regulation and didn't include this content, that notice would be an illegal notice and it would be grounds for a motion to dismiss the case. Let's see. And then we have more resources about the HUD 30-day notice requirement here and in the Green Book. Okay, so combining the CARES Act and the HUD 30-day notice, okay, so the CARES Act increases the notice time in private housing that's covered by the CARES Act to 30 days. And for many of the subsidized housing programs, most of the subsidized housing programs had a shorter notice requirement. So this CARES Act increases that notice requirement to 30 days. If the HUD notice requirement applies, and it applies in most of the subsidized housing program, we have the additional content that's required by HUD. On top of all that, the different subsidized housing programs have their own laws and regulations that predate the CARES Act and the HUD 30-day notice, and they have various procedural and content requirements as well. So if I were a landlord, let's say I was a landlord in a HUD subsidized housing project, I would have to be aware that the CARES Act applies to me, the HUD 30-day notice applies to me, but also the laws and regulations and handbooks for the HUD subsidized housing project. I would have to be sure I was compliant with all those. And if I'm a defense attorney, I want to see if the landlord has complied with all those things. And we'll get to those individual program requirements in a few minutes. Okay. Now, another thing that has to be done in all the subsidized subsidized housing cases is a notice of rights under the Violence Against Women Act. So that's often referred to as VAWA. And a lot of landlords think, well, I only have to have this form included if I know there's domestic violence going on in the apartment. And the answer to that is no, that's wrong. The whole point of this is to alert all tenants that if they are a victim of domestic violence, they have some additional rights and they should fill out a form a certification form that the landlord supplies. So the landlord is supposed to supply this with the eviction notice and with the eviction summons and complaint if it goes to court. And if the landlord doesn't do that, it's grounds for dismissal. Okay, now let's move into the individual housing programs. Let's spend a little more time on public housing, and then the other programs have relatively similar components, and I'll point out where they differ. Okay, so public housing authorities can evict for a number of grounds. Rent is probably the most common ground, and you'll see that in all these programs, but also various things related to conduct, serious or repeated violations of the lease, being over income. All of these subsidized housing programs have an income eligibility component. And so if the tenant becomes over income, they could be ineligible for the program. If their income increases, but they don't tell the public housing authority about it, they'll be in violation of the lease. And part of the reason they have to report that is because the rent is tied to the income. The rent is approximately 30% of the income. So my rent's $1,000, my rent would be approximately $300. There are a few adjustments in it that make it not exactly 30%. So let's say I get an increase, and so now I'm making, let's say, $1,100 a month. Then my rent would go up approximately to $330. Okay. So and so tenants need to report changes in income, changes in household size. Other grounds are different types of criminal activity, and you can see the whole list here. There is a termination process and eviction process in public housing. This is the most extensive administrative process of the different programs. And that's because in public housing, the government is actually the landlord. It's usually a municipal public housing authority, public housing agency. And so there are additional due process rights in the laws and regulations because of that tenant to governmental relationship. So there's a notice that the housing authority has to give, and it's got certain notice requirements. Now keep in mind, on top of those notice requirements would be the notice requirements of the HUD 30-day notice. So it'd have to be a 30-day notice with those notice requirements. If it's for non-payment of rent, I should have mentioned, I'll just back up for a second and go to the HUD 30-day notice. So the HUD 30-day notice only applies to non-payment of rent. The CARES Act, I believe, applies to breach of lease cases as well, but the courts have differed around the country as to whether that's the case. The HUD 30-day notice only applies to non-payment of rent. Okay, so let's go back to public housing. Okay, so we've got Public Housing Authority notice with content requirements of 966.4. And whenever I have a hyperlink to a regulation or a law or any of these resources, if you have the digital version of this, then you can click on those. Also, these are available on my website, and when we get to the end, I'll show you where that website is as well. Okay, so notice goes out. The notice, in most cases, gives the tenant a right to a grievance process that includes both an informal conference and a formal hearing. So if the tenant requests an informal conference, then there's an informal conference. Then the housing authority has to make a decision based on that conference. If it chooses to proceed with eviction, it has to send another notice out, kind of a summary of its decision, and telling the tenant has right to a formal hearing. If the tenant requests a formal hearing, then there's a formal hearing. It's not a court hearing, it's more of an administrative hearing. And then at the end of that, there's a decision whether to either continue with eviction or not. If the decision is to continue with the eviction, then the housing authority would have to start a proceeding in state court. How those proceedings are run varies a bit from either state court or if you're in the District of Columbia Court. But the case basically starts over again at that point. So the housing authority It's de novo, so the housing authority has to prove up its case in court, even if it prevailed at the informal conference and the formal hearing stage. Now, there are a number of defenses that tenants can raise in cases. Let's say it's a non-payment of rent case. Defenses could include improper notice, not including the VAWA notice, improperly calculating the rent, improperly including income, not adjusting income, not adjusting the rent as the tenant's income has changed. So there are a number of different things here that can be asserted as defenses in non-payment of rent cases. On top of those defenses would be defenses that are available under state law. So for instance, let's say, or local law. So let's say you have a law that says a tenant has the right to repair some disrepair and deduct that money from rent. And now the housing authority is trying to evict over that rent. And they might say, well, you didn't have the right to do this under HUD regulations. And the response to that is, well, state defenses apply as well. There's a lot of case law and a lot of regulatory language about public and subsidized housing operating both under federal law and under state law and litigating within state court systems. So it's not a matter of, it's not like this is admiralty law where the federal laws are out there and the states can't get in the way of it. This is the kind of law that's got to mix together. Okay, there are also defenses related to breach of lease. Again, could include not giving proper notice, not including the VAWA notice, violating the grievance process, the allegations not amounting to serious or repeated violations of material terms of the lease. There are various defenses related to domestic violence and related to disability. There are defenses related to allegations of criminal activity, and of course, defenses available under state law. Now, the Section 8 Housing Choice Voucher Program, this program differs from public housing in that private entities are the landlords, either individuals or private entities. The Public Housing Authority is not the landlord, so we don't have a tenant renting from the government. But a public housing authority administers the program. So public housing authority is involved, but it's not the landlord. I like to say it's a triangular relationship, where with public housing, you've got public housing, tenant. It's a linear relationship. With a Section 8 voucher, you've got public housing authority, landlord, and tenant. And they all contract with each other. Tenant applies for public housing and then gets a voucher and then looks out in the community for a landlord. If the landlord enters the program with the tenant, then they have a lease, and the tenant and public housing authority have a contract, and the housing authority has a contract with the landlord called the Housing Assistance Payment Contract or HAP contract. Okay. Now, the grounds for eviction, so because of this triangular relationship, we're going to talk about two different things. We're going to talk about eviction. That's where the landlord's trying to evict the tenant from the unit. We'll also talk a little bit about if the Public Housing Authority wants to terminate the voucher alleging the tenant's done something wrong. So the tenant has to worry about kind of satisfying both the Public Housing Authority and both the landlord to keep the triangle intact. Okay? Now, the landlord can evict for pretty similar reasons to public housing, rent, and various violations that we've discussed earlier. There are different lists of different types of criminal activity. We've got those things listed here as well. Now, the landlord is not required to evict the tenant who's violated the lease. And that's kind of the rule for almost all this stuff. There are a few laws and regulations that require, for instance, the Public Housing Authority to evict a tenant who's involved, for instance, with manufacturing meth. Okay. But for the most part, even with drug activity, alleged drug activity, public housing authorities are not required to evict tenants. They have discretion to do it, but they're not required. And you'll see that through all these programs. So here the landlord is not required to evict a tenant who's violated the lease, just like private landlords are not required to evict tenants who have violated the lease. It's an option they have, but they don't have to do it. Now, with Section 8 voucher program, the landlord may not terminate the tenancy for what's called other good cause unless it's something that the family did or failed to do. So in other words, let's say the landlord wants to exit the Section 8 voucher program. They got to wait till the end of the year to do that. But if the landlord is saying tenant owes me rent or tenant has violated the lease in a serious way, then the landlord can terminate the lease and file an eviction case in that first year. At the end of the first year, the owner has the ability to end the relationship without pointing at something that the tenant did wrong. There isn't a specific notice requirement in the voucher program. The landlord has to comply with whatever local notices there are. But because of the CARES Act, the landlord has to give a 30-day notice before filing. So this was a really big change in the voucher program. Pre-CARES Act, if you are in a jurisdiction that did not require a notice for non-payment of rent. In other words, the rent's due on the first, it's not paid. I file my case in the second. I don't have to give any advance notice. For those jurisdictions, the CARES Act was a big switch because then it said, okay, rent's due on the first, on the second. Now you can't file that case. You got to give that 30-day notice. And so then it runs into the beginning of the next month. If the tenant hasn't paid up at that point, cured the problem, then the landlord files. Okay. Let's see, what else do I want to say about this? The landlord does have to give, because of this triangular relationship, when the landlord files the eviction case against the tenant, the landlord has to notify the public housing authority that they're doing it. If the landlord doesn't do that, that can be grounds for dismissal. The defenses in these cases are pretty similar to public housing, like with the CARES Act, the VAWA notice, those other defenses that I discussed earlier. But again, the HUD 30-day notice requirement doesn't apply here. But we still have a 30-day notice requirement. So what we don't have here is we don't have the content requirements of the HUD 30-day notice applying to Section 8 vouchers. Okay, now triangular relationship again. What if the public housing authority wants to terminate the subsidy to the tenant? Okay, well, there can do that if there's a serious violation of the lease. The housing authority has to propose termination of the voucher. The termination process is a notice with content requirements. Now, because this is a termination of the voucher and not an eviction notice, the CARES Act does not apply to that. That only applies to eviction notices, and this is a termination from a subsidized housing program. But the 982 regs do talk about what the content of that notice is. So we have a notice. The tenant can request an informal hearing. This administrative process is truncated compared to what we just discussed with public housing. After the informal hearing, if the PHA decides to proceed with termination, the tenant has several options depending on the local court system. The tenant could appeal to an appellate court or could sue in federal or state district court. So for instance, in Minnesota, most often what happens is the tenant does an appeal by certiorari to the Minnesota Court of Appeals. Project-based voucher, this is a subsidized housing. So one of the things about the voucher, just going back for a second, is with this triangular relationship, if the tenant wants to end the relationship with the landlord, the tenant can follow a notice requirement, and then they don't lose their voucher. They essentially talk to the public housing authority about looking for housing elsewhere. And they look around, they find another landlord, and then we form the triangle again. Okay? So a lot of tenants like that program because they have geographic mobility. All the other subsidized housing programs, the tenant is stuck where the tenant rents. So if tenant has a project-based voucher, then they would be in a specific building, and that's where they would stay until they leave. either voluntarily or involuntarily. If they leave for whatever reason, they leave that subsidy behind. So the housing choice voucher program is the only one where the tenant has the ability to move that voucher from property to property. Every other one, like public housing and all the ones we're talking about now, ones we'll talk about in a few minutes, the subsidy is tied to the unit. Okay, so the grounds and the process are pretty similar here for the Section 8 for project-based vouchers. Now you might be wondering, well, how do you figure out whether you are, which of these programs? Yeah, well, usually the tenant's going to know. Sometimes there'll be a lease or a document that will specifically say. So for instance, with this next category, HUD subsidized housing projects, there'll be a lease that will have a reference to HUD Handbook 4350.3. So usually the tenant will know. I have a tenancies table on my subsidized housing website that gives different ways to kind of examine if the tenant doesn't know for sure how to figure out based on different actors what type of subsidized housing program you have. Okay, so this type of subsidized housing program covers a lot of different types of programs. You might be wondering why. It's different programs under different administrations, start at different times, and they've been kind of layered together under this handbook. The eviction grounds, pretty similar to what we have with public housing. The main difference between public housing and the other subsidized housing programs is in the area of alleged drug-related criminal activity. In public housing, the activity could occur anywhere, unfortunately, in the universe, and it would be grounds for eviction if they could prove it. For most of the other subsidized housing programs, it's kind of on or near the property, so the geographic location is more constricted. But the grounds are pretty similar here with all the subsidized housing programs. Take a little drink of water there. Termination process is much less administration than in public housing. Landlord has a notice with notice requirements. A tenant has 10 days to request a meeting with management to discuss it. And then if the landlord decides to proceed with the eviction, they have to file a case in court. Defenses are similar to what we've discussed already with public housing. The HUD 30-day notice requirement does apply to this program as well as the VAWA notice and the CARES Act. The RAD program is a variation on public housing. Some localities have converted their public housing into either project-based Section 8, which we just discussed, or used it so the HUD subsidized projects, or with Section 8 vouchers, project-based vouchers. So if that's the property, then the landlord has to comply with what we've discussed already. So if they're in a HUD Handbook 4350 property, they got to follow that. If they are a project-based voucher program, they have to follow that.
And we have one question in the chat clarifying if HUD can terminate a tenant's voucher and how, if there are due process requirements with that.
Yep. So going back to the voucher, we'll just use the agenda to go back, and we'll go back to the Housing Choice Voucher Program. Okay, they have to have grounds, so it can't be for, well, let's see, let's go to termination here. Okay, so here we are at termination. Okay, wait, here we are. Okay, so they have to have grounds. Then the due process is they have to give a notice, and the notice has content requirements in it, saying, say what are the grounds of termination. Then the tenant requests an informal hearing, and so then the informal hearing is the administrative due process that's involved. If the PHA decides to continue with termination, then the tenant appeals that decision, including whatever happened at the informal hearing, to an appellate court or sues in federal state district court. So due process kind of rears its head in two places. One is in the informal hearing, and there are due process requirements in the 982 regulations. And then if the tenant then sues or appeals, then there is due process there in a review capacity.
Thank you.
Sure. Okay, so now I'm going to go to the mod rehab program. I'm going to go through these fairly quickly. Some of these programs are less common, but if you are in the mod rehab program, again, we have similar grounds. We have a notice with content requirements, but no administrative process. So if the tenant doesn't move out at the end of the notice period, then the landlord files in court and the tenant has the due process within the court system. The Home Investment Partnership Program, similar grounds, similar procedure. We've got notice with content requirements. And whenever I say notice with content requirements, keep in mind, if it's a non-payment of rent case, for almost all these programs, we've got the additional content requirements of the HUD 30-day notice. And the VAWA notice applies in all cases. And because the CARES Act is still around, all of these notices have to be at least 30 days. Okay. And then the due process is in state court. We have a shelter. We have these different kind of social service based housing programs. These are housing programs that have a social service component in them. They have this additional kind of requirement of being, I don't know, humanistic in determining whether they're going to evict or not. All these programs have language about, evaluating the circumstances only in the most severe cases. So tenants have an argument that if they have extenuating circumstances, these are programs that should not be evicted now. These programs have a notice with content requirements. The tenant can appeal that notice to the landlord. The landlord has to make some sort of decision on that. If the landlord proceeds, then it ends up being in state court. The IRS has a program. It's called the Low-Income Housing Tax Credit. I frankly think the IRS never wanted to have it, so they've never done any regulations on it. So there's not a lot built into that, which can be good or bad. Okay, so the one element that's in the law is that they have to have good cause. So in other words, they have to have good cause is a concept that means you have to have a good reason for evicting somebody. And it might be a good business reason, like I don't want to be in the program anymore, or a conduct-based reason. It can't just be no reason at all. Okay? And it certainly can't be retaliatory, can't be discriminatory, things like that. Okay. But we don't have regulations talking about any level of due process or anything. So what the landlord's got to do is they have to give a CARES Act notice. Since they're not covered by the HUD 30-day notice, so they have to give a CARES Act notice. They'd have to give a VAWA notice, and then they'd have to file their case in court, and then the tenant would have defenses more related to does the landlord have good cause or not, and then defenses that would be available under local law. And we'll talk about some of those in a few minutes. Okay, now, everything we talked about before was HUD, except IRS was last. And now we're going to talk about the Ag Department. There's a whole subsidized housing program in rural areas around the country, and it's administered by the Ag Department. It's called the Rural Housing Service Program. It has similar grounds for eviction. And good cause is a little more defined in the Rural Housing Service Program than in the HUD programs. It's got a more extensive termination process, not quite as much as public housing, but more than the other subsidized housing programs. There's a notice with content requirements. Tenant specifically has the time to cure that. It's a violation notice, not a termination notice, and tenant has time to cure the violation. And if the landlord thinks the tenant hasn't done it, the landlord would have to give a termination notice. It has different content requirements. And then the landlord would have to file in state court. That's where the due process would occur. The defenses are more extensive than in the HUD programs, and we could spend a whole hour talking about why that's the case. But that is the case, and I have more details of that both in my answer forms, but also in some of my other slides. The CARES Act notice and the VAWA notice apply to the Rural Housing Service, but the HUD 30-day notice does not apply. Now, if you're dealing with alleged criminal activity, it's kind of like a whole nother set of analysis, because now we're looking at what's the type of activity, who committed it, where did it occur, and whom was affected. Okay. And so don't have time to go into that, but I've got a much longer slideshow and a section in the Green Book that goes into a lot of detail about it. So it's a lot of times people think, and I've seen Public Housing Authority attorneys say, hey, we've got criminal activity here, your client loses. And it's like, slow down, slow down. We need to look at who's alleged to have done it, when did it happen, where did it happen, what was the activity. We got to look at all that stuff. We got to look at the elements of the alleged crime. So for instance, most types of criminal activity in the criminal justice system require intent. Okay. So if someone, let's say you've got possession of a drug, but someone slipped it in your bag and you didn't know it was there. So you possess this drug, but you did not have the criminal intent to possess this drug. I would say that is not drug-related criminal activity. So a different lens you put on when you're looking at these types of cases, and I've got a lot of resources on that. Okay, so now talking about tenants in both private and public and subsidized housing. What kind of federal laws do we need to know a little bit about? Okay, well, I talked about the CARES Act. That applies to some private properties, depending on what their loans are. But we also have laws related to reasonable accommodation of disabilities. That applies to private housing as well as subsidized housing. That essentially means landlords have an obligation to reasonably accommodate person's disability. So if the disability has some causal connection to an alleged violation of the lease, and there's something that could be done to mitigate that so that the tenant no longer violates the lease, the landlord has to roll with that. So that's what reasonable accommodation is. There's also a Service Members Civil Relief Act. In some jurisdictions, this provides more time and more defenses to tenants if they are a member of like the National Guard or active service with the military. But with all this, we need to not forget about local laws. Okay, so whenever there's an eviction case, it starts some way. And in most jurisdictions, the court doesn't have personal jurisdiction over the defendant unless the landlord starts the case the right way. Now, that can be done by getting the court papers to the tenant by personal service, and some jurisdictions allow for substitute service on another person or mail and posting service. And so in every eviction case, you need to not forget about the things that apply to every eviction case, which is personal jurisdiction. If there's no personal jurisdiction over the defendant, the court has no power to evict the tenant. Preconditional defenses. These are things like, is the plaintiff the right party? Is there an agent for the plaintiff? Is that person a proper agent? If it's a corporation, can it proceed without an attorney or does it need an attorney? Did the landlord have to disclose information to the tenant? Did the landlord have to register the property with like a licensing agency? Things like that. Rent defenses. Localities might have notice requirements. So like in Minnesota, we have a 14-day notice requirement statewide. In the city of Minneapolis, we have a 30-day notice requirement. So if I were a landlord in Minneapolis and these notice requirements have content requirements. So if I were a landlord in Minneapolis and I was filing a case for non-payment of rent and public housing, I'd have to comply with the CARES Act notice, the HUD 30-day notice, the VAWA notice, the state of Minnesota 14-day notice, and the city of Minneapolis 30-day notice. That doesn't mean I have to give a whole bunch of notices, but the aggregate content of my notice would have to comply with all those. So if I'm on the defensive side of that case, I'm comparing that notice with all those things to see if everything's there. And if it's not there, I'm going to ask that the case be dismissed for not complying with whichever law was violated. A lot of jurisdictions have habitability defenses, like if it's a non-payment of rent case, I shouldn't owe all the rent because of habitability issues. There's there's a list here of other things that I might raise. Um, these don't apply in all jurisdictions, but they may or may not apply. It's good to figure out if they apply or not. When you're in private housing, a landlord often can end for instance, a month-to-month lease by simply giving a 1 month notice without giving any kind of reason. At least we have that in the case of Minnesota, and that's pretty common around the country. Okay. So if let's say you're in a jurisdiction that requires a 1 month notice to end a month-to-month lease, there still are defenses that could apply to that, giving 15 days notice instead of 30 days notice. Retaliation, waiver, discrimination, domestic violence. There are a number of different defenses that can be raised there depending on what you have in your jurisdiction. For breach of lease defenses, they can include, was the breach a serious breach or was it a more modest breach? Does the landlord retain rights in the lease to evict for it? Again, waiver, discrimination, reasonable accommodation of disabilities, things like that can come up. Here are some other ones as well. The kind of relief you can ask for in an eviction case is very dependent on the jurisdiction. Often, from a tenant standpoint, you want the tenant to win, so that's either a dismissal or entry judgment or summary judgment. But there are other types of relief you might be looking at pre-decision, like scheduling, having time for discovery, limiting the scope of evidence in the case through a motion eliminate, things like that. Substantive relief could include a rent reduction in a non-payment of rent case, for instance, for habitability problems, different types of penalties or costs if landlords are violating laws that have those types of penalties in them. Some jurisdictions will award attorney's fees to the attorney who's representing a successful tenant, things like that. So I wanted to say a brief pitch for not limiting your involvement with tenants to representing tenants in court and eviction cases. All the things that we've discussed so far have resulted from either litigation or from public policy advocacy. The law that we have in Minnesota that requires a 14-day notice is something for which I lobbied a couple of years ago. Okay. So the law is not static. It can change based on who changes it. And so what are ways that people can be involved with public advocacy? Well, one is with legislative bodies like Congress, like city councils, with state legislatures to enact laws or ordinances that are more protective of tenants. Advocacy with public housing authorities over their policies. Public housing authorities do not have to evict in most of the cases we've discussed. I'm not saying they should never evict. I mean, if someone never paid the rent and is never going to pay the rent, fine, evict. But there are certainly cases where public housing authorities could say, okay, we have a vulnerable person here. Maybe what we need to do is help this person get a representative payee to help that person manage their income and to pay their rent so that they pay their rent. Other ways to affect policy change is through appeals of decisions to higher courts for precedential decisions, to do affirmative litigation challenging actions that are violative of the law, and working with the media. I've worked with the media a lot over the years. You never know how the media is going to take a situation. But for the most part, I've had good experiences with the media. And so, for instance, we had a city that was using a crime-free ordinance to force landlords to evict tenants where they were not prosecuting the tenants. They're using it as kind of like an alternative to the criminal justice system. And I worked with a TV station to publicize it. And the community kind of rose up and said, that's not us. We don't want this to be happening. And it led to focus groups that ultimately led to a repeal of that ordinance. And so the media can be a strategy for affecting change through essentially shaming actors to not do what they're doing. So we've got about 8 minutes left. Here's my contact information. I think one thing I'll do right now is just show you my website. So let me go over to that quickly. So I have this website. It's called povertylaw.homestead.com. And I've got a link to it, I think, earlier in the slides under resources. And this is a site that I maintain for classes that I teach, poverty law class. And I have a housing law section here. And in the housing law, it's Minnesota based, but there's a lot of stuff in there that's not Minnesota based. So for instance, if you go to the home page and go down to housing law and you go to public and subsidized housing, you'll see the slideshow that we just did. Okay. I also have there the long slideshow. So this is the one where you'd be 159, okay, slides. So you're going to go into more details about that. If you're doing a criminal activity case, I've got slideshow there. I've got a journal article on it, but I've also got a slideshow on it. Again, it's another long one, around 93 slides. So you can get more in the weeds on that stuff. Now, I talked a little bit about a tenancies table. So I'll just show you where that is. I have that under resources, research links and referrals. Let's see. Nope, I don't have that there. Where do I have that? Oh, I know. I remember. I have that in public and subsidized housing. Here's the tenancies table. The tenancies table helps you look at the summary here to try to figure out what type of housing program you're in. So for instance, with public housing, subsidy stays with Public Housing Authority. So that's the landlord, and the tenant pays 30% of income for rent. Now compare that with the Housing Choice Voucher Program. Here, the tenant obtains a subsidy from the Public Housing Authority, Section 8 office, finds private housing. The PHA subsidized, subsidy stays with the tenant unless terminated. Okay, so you can use this as a way to try to figure out if the tenant doesn't already know what type of program they're in. And then briefly, I'll just show you, let's see, I'll show you what an answer form looks like. So for instance, with public housing, this is a Minnesota-based answer form. We have a right to counsel in some public housing cases, so I've got that listed here. I've got certain threshold, I've got the CARES Act listed here, and then I've got responses to allegations, I've got different service defenses that we have. And then when we get to preconditions, I have the ones under federal laws. That's where I have the VAWA Act notice that I talked about earlier. And then we've got things under state law. And when we get to pre-eviction notice and procedure, I've got all that grievance process that we talked about earlier. And then if we're looking at non-payment of rent, I make a reference to the CARES Act, but since it's public housing, I also make reference to the HUD 30-day notice. So these are the things that are available on my website. I'm just going to go back to the slides just to see. I think I had that. Well, I've got housing law in Minnesota here, so that's where you would find all that stuff. That's kind of a subgroup of the poverty law website.
Awesome. Thank you so much, Larry, for your wonderful presentation, wealth of resources, and just all of the amazing work that you've done in this space. We really appreciate you taking some time out of your day to come, share these resources and your knowledge with us. We have a couple questions with a couple minutes left. Yalda was wondering if there's any federal legislation that you're currently watching that could impact housing law or other recent changes on the federal level impacting housing programs.
Yes, there is, and I'm not happy about it. So there are there are bills to get rid of the CARES Act. Notice there's a proposal that HUD may try to rescind the 30-day notice requirement. And there are proposed cuts to housing programs. And so none of these things are final at this point. They're things that are kind of circulating around, but that stuff's out there. I believe the budget bill that came out reduced money to some of the subsidized living programs. So there's definitely stuff kind of on the horizon, but it hasn't happened yet. And depending on what happens and when it happens and how it happens, there may be litigation involved.
Keep our fingers crossed that doesn't happen. Do the housing programs mentioned in the presentation apply to lawful permanent residents or other non-citizens?
Yeah, so um, there are a number of different subsidized housing programs where people of different citizenship stratas can be participating. For those without citizenship, so those are undocumented, they're generally not eligible for these programs.
Mhm. And I know we touched a little bit on this in the presentation, but if you could just clarify, what happens if the notice is given to the tenants do not fulfill all of the requirements of the content notice side? Is the eviction set aside? How do tenants normally challenge that?
Okay, so the way they would challenge that is, for instance, they can assert that with the landlord, and maybe the landlord fixes it. If they don't assert it with the landlord and the landlord files an eviction case, the tenant asserts that as an affirmative defense to the eviction case, and then it would be up to the judge to determine whether the notice was compliant or not. It's been my experience, you certainly have you have judges of all different stripes, and some are going to take these more seriously than others. But essentially, that's the argument that you're making, is that without giving the proper notice, I mean, another way to put this in lawyer language is that the plaintiff has failed to state a claim upon which relief can be granted because the notice is a precondition to the relief that's being sought.
Well, thank you again. With our 1 minute left, if you want to share your favorite pianist, Larry is a professional jazz player in his free time, so we'd love to hear.
Bill Evans. So Bill Evans played with Miles Davis on Kind of Blue. He had a short life. He only lived to be 51, so he died in 1980. But quite a catalog there. I'm not saying the others aren't great because, Duke Ellington and Count Basie and Herbie Hancock and Chick Corea. I mean, there's a long list. But I'd say Bill's my favorite. And last time I was in DC for a few days, I did play at one of the clubs out there. So if I'm out there again sometime, maybe I'll see if I can put that together.
Please let us know. We'd love to attend and see you. All right. Well, thank you again so much. We really appreciate it. I learned so much. I'm sure everyone on the presentation also learned so much. So thank you again, Larry.
Yep. And if people have other questions, when they get the slides, they can reach out to me directly and I'll do the best I can.
Awesome. Thank you.
Thank you.